Hello viewers and welcome to this package on departmental inquiry. In the first episode, we are going to discuss the concept of an inquiry and a charge sheet. In the second episode, we will be discussing the procedural part of an inquiry. And in the third episode, we will be discussing the findings and punishment part of an inquiry. We have with us Advocate Srikant Malegaonkar, who will throw light on these concepts. Now first let us see the concept of an inquiry.
An inquiry is nothing but a trial which is held within the industry or within the department, and that is why it is either called a domestic inquiry or a departmental inquiry. Now why is it so necessary to hold a domestic inquiry or a departmental inquiry? Now if at all some workman commits a misconduct or he is alleged to have committed a misconduct, well then the misconduct has to be proved. How are you to prove the concerned misconduct? Now one would appreciate that after industrial adjudication came into picture or after the advent of industrial law, it is seen that the law of contract, pure and simple, cannot be accepted in an industry. It should be supported with social security. And how are you to mete out this element of social security to the concerned workman? So before he is dismissed or discharged or terminated or removed from service, it's in the fitness of things that we hold an inquiry. And this inquiry is nothing but a departmental inquiry. Now the reason for holding this is very simple, because tomorrow if it is found out that the workman was totally innocent, well then the industrial tribunal or the labor court or whichever is the tribunal which is entrusted with this function will set aside the dismissal or discharge and direct a reinstatement of the concerned workman. Now all these things have to be catered to in the inquiry, and this is nothing but what we call as an inquiry, which is a quasi-judicial proceeding in which, simply speaking, there is a duty on the part of the inquiry officer to act judiciously.
Now let's understand what is a preliminary inquiry.
A preliminary inquiry, as the name itself suggests, is an inquiry which is preliminary in nature. Now this is something different, very different from the regular inquiry which we are going to see further. Now what is a preliminary inquiry? A preliminary inquiry is an inquiry which is basically held by the employer to find out whether a prima facie case of any misconduct exists as regards the concerned workman. A misconduct is alleged, that he has committed that sort of a misconduct, but the employer wants to satisfy himself and to find out whether really such sort of an allegation has got an ostensible value. Is there some sense in such an allegation, for which he himself might proceed to find out whether some sort of such a thing, that is a misconduct, exists or it does not exist. Now the reason for all these things is very simple, because conducting a regular inquiry is a very serious business, and it's a serious matter which might have undesirable effects. It might even have friction. There might be an unrest in the industry. Say the recognized union might take it in some other parlance, that suppose if there is victimization or whatever it is. So instead of going into all these areas, all of a sudden the employer might himself think that let me at least find out whether there is some sense in this sort of an allegation of misconduct which is spelled out against the concerned workman. This in short is nothing but a preliminary inquiry, which I will repeat that it is for the subjective satisfaction of the employer himself.
Now let's see what is the difference between the preliminary inquiry and a regular inquiry.
Now basically the difference is of purpose, that a preliminary inquiry is for the subjective satisfaction of the employer himself, whereas the regular inquiry is held to find out whether really the concerned workman has committed the alleged misconduct or not. Now in a regular inquiry, we find that all the procedural formalities of an inquiry have to be followed, whereas the same are absent with the case of a regular inquiry. Now before some punitive action is to be taken against the concerned workman, with regard to his conduct or with regard to his work, the concerned employer might try to find out whether he has really committed it or not, or prima facie what exists is what he does in a preliminary inquiry. Now the same is missing with a regular inquiry, wherein a detailed procedure and all those things are to be followed. One will appreciate that a preliminary inquiry can be held ex parte, whereas this is not the case with the regular inquiry. In a preliminary inquiry, the worker need not be heard, whereas the principles of natural justice demand that at any cost the workman has to be heard in the regular inquiry. Again, the principles of natural justice demand that the workman should be given a right of cross-examination in the regular inquiry. Now, this is again missing with the preliminary inquiry. A preliminary inquiry might not result into any punishment or exoneration of the worker, whereas the regular inquiry might result into punishment, or it might declare the concerned workman to be innocent. Now, all these things are to be observed in a preliminary inquiry by the concerned employer. All these things means only for the subjective satisfaction of himself. And as I just now mentioned, the right to cross-examination, the right to be heard, etc. need not be given in a preliminary inquiry. Of course, one word of caution: if the standing orders or the rules of the enterprise or the rules of the establishment or the industry require that the preliminary inquiry must be held at any cost, it has to be held at any cost. Else, it can be said that holding a preliminary inquiry is optional. But there is one more thing to be remembered, that is that even if the employer declares or the preliminary inquiry officer declares the concerned workman to be innocent after the holding of a preliminary inquiry, there is no bar in industrial law for the employer to hold the regular inquiry. He may yet hold the regular inquiry. This is to be seen.
कुछ सुना तुमने?
क्या?
अपना जो रमेश है ना, अपने सुपरवाइजर साहब बोल रहे थे कि उसने फैक्ट्री में चोरी की और फोरमैन साहब को मारा भी।
क्या कह रहे हो?
हाँ, इसलिए तो मैं आपके पास आया हूँ। मुझे तो नहीं ऐसा लगता कि रमेश ऐसा कुछ करेगा।
फिक्र मत करो, मैं साहब से बात करूंगा।
ये बराबर है, लेकिन मैं कंपनी में नया आया हूँ। इस कंपनी के जो कायदे कानून जो है वो मुझे कुछ मालूम नहीं है। रमेश ऐसा करेगा ऐसे मुझे लगता भी नहीं है। क्या कंपनी अभी उसे डिसमिस करेगी?
अरे नहीं पगले,
फिर
ऐसे नहीं होता। अभी कंपनी इसमें पूरी डिपार्टमेंटल इंक्वायरी करेगी। लेकिन तुम्हें जैसे लगता है ना,
हाँ।
वैसे मुझे भी नहीं लगता कि रमेश ने ऐसा कुछ किया होगा।
अच्छा,
मैं तुम्हें समझाता हूँ।
हाँ।
देखो, मैंने यहाँ पूरी ज़िंदगी बताई है नौकरी करते हुए। देखो, इस मामले में कंपनी अब डिपार्टमेंटल इंक्वायरी करेगी।
ये इंक्वायरी क्या होती है?
हाँ, अब ये देखो, अपना ये जो रमेश है,
हाँ।
उसके ऊपर इल्ज़ाम है कि उसने चोरी की और फोरमैन साहब को भी मारा। लेकिन हो सकता है रमेश ने ऐसा कुछ किया भी ना हो।
बराबर है, लेकिन ऐसा इसका फैसला कैसे होगा? कौन करेगा?
हाँ, अब तुम कुछ समझे। इसका फैसला हो जाना चाहिए।
हाँ।
और फैसला तभी होगा जब कुछ पूछताछ होगी, कुछ छानबीन होगी।
हाँ।
फिर रमेश के जो साथी है, जो उसके साथ काम करते हैं, उनसे कुछ पूछा जाएगा, जवाब होंगे, लिखापढ़ी होगी।
क्या ये सब जरूरी होती है?
बेशक। फर्ज करो रमेश की जगह तुम हो, तो तुम भी तो कहोगे ना कि ये जो सब इल्ज़ाम है चोरी और मारामारी के, ये प्रूव हो जाने चाहिए। इसके लिए ये इंक्वायरी होगी।
अच्छा, भाई साहब ये बताओ, ये इंक्वायरी जो तुम आप बोल रहे हैं, ये क्या होती है और कैसे होती है?
देखो, अब ये कंपनी खुद को यकीन दिलाने के लिए
हाँ।
कि रमेश ने ये सब कुछ किया है,
हाँ।
तो अपनी तरफ से एक इंक्वायरी करेगी। रमेश के जो साथी है, साहब है, फोरमैन है, उन सब से पूछा जाएगा। इसके ऊपर एक रिपोर्ट बनेगी। इस रिपोर्ट के ऊपर कंपनी गौर करेगी। अगर कंपनी को लगता है कि कहीं ना कहीं रमेश ने कुछ ना कुछ गड़बड़ की है, तो आगे जाके कंपनी उसकी डिपार्टमेंटल इंक्वायरी करेगी।
अच्छा, यानी जब पूछताछ होती है उसे इंक्वायरी नहीं कहते?
नहीं,
फिर
वो इंक्वायरी ही होती है।
हाँ।
लेकिन वो कंपनी ने अपने लिए की है ना।
हाँ।
इसमें रमेश से कुछ भी पूछा ना जाएगा, क्योंकि रमेश का इसके साथ कुछ भी संबंध ही नहीं होता।
अच्छा। और अगर कंपनी को महसूस हुआ
हाँ।
कि रमेश ने चोरी की है, तो उसको सजा हो जाती है क्या?
नहीं,
फिर
तब आगे जाके सचमुच डिपार्टमेंटल इंक्वायरी होगी, जिसके लिए रमेश को कंपनी चार्जशीट इशू करेगी।
क्या करेगी?
चार्जशीट।
ये चार्जशीट क्या होता है?
देखो, अगर ये जो इल्ज़ाम है
हाँ।
चोरी और मारामारी के,
हाँ।
ये अगर कंपनी के रूल में बिठा दिए गए
अच्छा।
तो वो हो गए चार्ज।
हाँ।
और कंपनी के जो रूल है उसे कहते हैं स्टैंडिंग ऑर्डर।
अच्छा
ये स्टैंडिंग ऑर्डर के नंबर के साथ अगर ये चार्ज जोड़े जाएंगे और उसका ब्यौरा दिया जाएगा तो बन जाएगी चार्जशीट।
अच्छा, इसमें क्या क्या होता है?
इस चार्जशीट में
हाँ।
देखो, इस चार्जशीट में क्या होता है,
हाँ।
तो अगर ये जो इल्ज़ाम है चोरी के, मानो इसने रमेश ने चोरी की,
हाँ।
तो ये चोरी कब की, कहाँ की, कौन सी चीज़ की, इस सब का पूरा वर्णन उसमें आना जरूरी है।
अच्छा, ये सब जरूरी होता है?
क्यों नहीं, बिल्कुल ज़रूरी है। नहीं तो रमेश को कैसे पता चलेगा कि उसके ऊपर क्या इल्ज़ाम है और उसके क्या उत्तर देना है। उसको तो जवाब तो देना है ना।
बराबर।
इसलिए
ये चार्जशीट में और क्या क्या होता है?
देखो, चार्जशीट में
हाँ।
और ये आता है कि अगर उसकी इंक्वायरी होने वाली है तो रमेश को बताना जरूरी है कि उसकी इंक्वायरी होने वाली है।
बराबर।
इसके साथ साथ ये इंक्वायरी कब होने वाली है, कहाँ होने वाली है, इसका भी ब्यौरा आ जाएगा।
अच्छा।
उसके आगे चल करके अगर इस इंक्वायरी के दौरान अगर रमेश को सस्पेंड किया जाता है काम से तो उसे निर्वाह भत्ता मिलेगा, यानी कि हाँ, सब्सिस्टेंस अलाउंस
वो भी मिलता है?
हाँ, वो भी मिलेगा। और सबसे अहम बात यह है इस चार्जशीट में कि उसे अपने बचाव का पूरा मौका दिया जाएगा। मतलब ये कि अगर वो चाहता है तो अपने साथ अपने कोई सहयोगी या वकील या यूनियन लीडर को भी उसे लाने की इजाज़त है।
अच्छा, ये भी इजाज़त मिलती है?
हाँ।
अच्छा भाई साहब, ये बताओ, ये चार्जशीट में क्या नहीं होना चाहिए?
इस चार्जशीट में ये बिल्कुल नहीं होना चाहिए कि कंपनी ने रमेश को दोषी मान लिया है।
अच्छा।
क्योंकि यही साबित करने के लिए तो ये इंक्वायरी है।
हाँ।
बराबर है कि नहीं। और तो और ये चार्जशीट जो रहती है वो गोल मटोल नहीं होनी चाहिए, यानी कि वेग चार्जशीट नहीं होनी चाहिए।
अच्छा, मैं समझ गया।
हाँ।
Interesting, isn't it? Now let's see what are the features of a good charge sheet.
A charge sheet is basically a document which contains the charges. Say a workman has committed some sort of a misconduct. Now this misconduct is to be proved against him. How are you to prove it? For which the concerned worker or the workman should be charged with that sort of a misconduct. Now a charge sheet is a document which will contain that charge. Now another question arises is who can serve a charge sheet? Now a charge sheet may be made on the basis of a report from anybody. Say there are two workmen and they have had an assault with each other, and one makes a report against the other, or they make a counter report against each other. Now the management might want to probe this matter and to see that henceforth there is no indiscipline. So all the other formalities, say for example the preliminary inquiry is conducted, etc. So likewise we might go on after the charge sheet to the regular inquiry, but a charge sheet is a must. Now a charge sheet might be given suo motu by the employer or upon a report, or it might even be given by some subordinate officer if a power to that effect is delegated to that concerned officer. So any of these people might serve a charge sheet, and ultimately we remember one thing, that the inquiry begins after the charge sheet is given. Now it is at this point of time the machinery of the inquiry is set in motion, and of course without a charge sheet the regular inquiry cannot begin itself. Now let us understand as to what are the characteristics, features of a good charge sheet. A charge sheet certainly has some good features. First and foremost, it should not be a vague charge sheet. And what is the meaning of the word called vague? Now this meaning is not defined anywhere. However, our socially conscious judiciary through n number of judgments have thrown light on this word as to what is the meaning of the word vague. Now a charge which is capable of being understood, and it is so intelligently understood by the concerned workman so as to enable him to make a representation, is not a vague charge. He is to understand it, and the degree of understanding should be such so as to enable him to make a representation. Now this test has to be satisfied so as to qualify the charge as a charge that which is not vague. Say for example, nowadays you are not behaving properly. What do you convey by this? Nowadays means when, what time, which date. It conveys nothing. And then we say that the charge is a vague charge. Or nowadays your behavior is not satisfactory. What do you mean by satisfactory? This is again a vague charge. Or you are carrying on a propaganda against our company. What propaganda? What exact words did he use? What were the exact sentences? All these things have to be mentioned. A second ingredient or a characteristic feature of a good charge sheet is that it should mention material particulars. Now what are material particulars? All the interrogatories, say for example when, where, what, how, date, timing, everything has to be present in the charge sheet. Say for example in the case of theft, something is stolen. What is stolen? When is it stolen? What is the quantity of that thing which is stolen? Or what was the shift? What was the date? What was the time? Who were present? Who were the witnesses? Who was absent? How do you infer? All these material particulars should be present in the charge sheet, else again the same thing. How is the worker going to make a representation against that allegation which is contained in the charge sheet, of which the material particulars are not given? So it's in the fitness of things you give the material particulars. And at last but not the least, the issue should not be prejudged. Say a charge sheet which reads that I am of the opinion that you have committed a misconduct. Well then, why are you basically conducting the inquiry if you are already of the opinion? So words like I am not sure you have committed the misconduct,